Past president, Lords and Honorable Justice Supreme Bhattacharya.
कल इसको भी लगवा
है ना लोग आते
My lord, may I permit to mention one matter to inclusion in the tally?
give it. All. Item number 1. Yeah. Item number 2.
But item number 2, I am appearing on behalf of the petition.
Oh yes, yesterday
That
was.
matter, yes, that is. But I have a specific instruction to withdraw the matter, Lordship. And
Disrespect to me.
What is the why? What does it mean losing a forum?
my lord, since thereafter a single bench judgment was passed, my lord, if I apprise before your lordship, then the single bench will be.
Did you move to the single bench?
Thereafter, in January, in the month of January, there was an order that when the tribunal is not functioning, then I can approach before the single bench of these High Court. So I filed a way prior to that judgment. So that is why, and WPST also filed prior to that judgment, Lordship.
No,
And
but in this case, you have already invoked the tribunal's jurisdiction.
But tribunal never, no admission hearing was given to the by the tribunal. And my lord, I am seeking a leave to withdraw the original application. My lord, a necessary order be passed for withdrawal of the original.
Item number 3,
to be made before and considered by.
Item 3, IFF for the petition. Study leave formula, sir. Study leave. স্যার একটাই কপি আছে স্যার, আপনি আমার থেকে দেখতে পারেন। না না, if your lordship kindly turns to straight away, if your lordship kindly turns to page number 134 of the WPST, my lord.
Where is 25/11/25?
Lordship,
But there is an order of 25/11/25 by
2511. 2511 is at 142, my lord. This is the reasoned order that has been passed pursuant to your lordship's order. May I place, my lord?
we are reading it just.
অর্ডারটা দেখিয়েছি। না আমি ওটা দেখছি, হ্যাঁ ওটা দেখছি। আরে দাঁড়া, আমাকে আমার মতন পয়েন্ট আউট করতে দাও, কালকে তোমার থেকে পুরোটা শুনে নাও।
Yes.
Lord, this is the third round of litigation, and my lord, second time I am before your lordship. The impugn rejection order, my lord, if your lordship see,
That's what we are looking at.
my lord, it is a cut, copy, paste of the previous one. Even, my lord, I would say, my lord, the last time your lordship would remember that the director, while passing the rejection order, made a mistake. I applied for 2 years. He said 3 years. This time the same mistake is there. Even your lordship has after your lordship has passed the order. My lord, I will indicate. But first I will come up to your lordship's order first. But that is at page 134. It starts from. Such type of malafide. Reports and everything is in my hand. Well, kindly come to para 6
Page one,
of your lordship's order,
page 135.
page 135. 135. Division bench order. হারিয়ে গেছে দাদা, আবার কি আছে? আধার কার্ড হয়ে গেছে, যাও না। হ্যাঁ,
Yes,
may I just place your lordship's order on last time?
yes, we have read it. What do you want to, you are highlighting any part of that order?
Well, I want to highlight from paragraph 6, my lord. Lord, your lordship would find, my lord, we have heard the rival submission of both the parties, and upon consideration of the submission and the study leave provisions contained in Appendix 5 of the West Bengal Service Rules Part 1, we find that the condition for grant of study leave have been specified by a general order issued under Rule 197 of the West Bengal Service Rules. As per the rules, when an application is made for study leave, it is to be considered by making assessment of several relevant parameters. The authority is required to see whether the course which the employee seeks to pursue is a special course of study consisting of higher studies of specialized training in a professional or technical subject. My lord, this has not been considered. Same, my lord, having a direct and close connection with the sphere of his duty. The rules further contain provision as to maximum period for which the study leave may be granted, the number of years of service as a prerequisite to the application being made for study leave, and a report regarding the admissibility of study leave from the head of the office, amongst other requirements under the rules. In the present case, the head of the writ petitioner's office has already submitted a report which he have extracted above. The order of the head of the department rejecting the writ petitioner's claim is in variance with the report. That apart, we find that the order of the head of the department dated 7/2/2025, that is the last rejection order, which is without reference to any parameters on which assessment was required to be done in terms of the study leave rules contained in appendix number 5. The order is therefore clearly unsustainable. The authority is required to make detailed consideration of the application and does not have absolute discretion to reject the same in the way it has been done by the head of the department. The order is passed without considering the report of the head of the office, without considering various parameters which are required to be considered under the rules. We therefore set aside the order dated 7/2/2025. Writ petition is accordingly allowed. We further allow the writ petitioner 2 weeks' time to make an application. My lord, this I have made. And subsequently, my lord, the rejection order has come. My lord, I will just take your lordship to the previous rejection order. My lord, it is the same. The mistakes are also same. My lord, kindly come, my lord. The previous rescind order. আগেরটা কত পেজ ছিল?
130. Page number 130. Page 130.
But page 130, it starts from. Well, kindly see. This was the previous rejection order. Your lordship set aside, my lord. But I skip over the first portion, second portion. Now, my lord, your lordship would find this time also A, B, C, D, these portions were given at page 131, Duare Sarkar under the state flagship. My lord, very important is, my lord, there at page 131, the second paragraph, whereas considering the notional as well as the state interest on the programs and national, as well as the state interest of the programs and its smooth functioning in the interest of public service, the release of the applicant for long 3 years. But I have applied for 2 years, he is stating 3 years. Will create an inevitable difficulty in the administration. Now, my lord, kindly see the fresh rescind order, my lord, same. 142. My lord, I skip over the upper portions, my lord. My lord, page 144. The relevant part. Even the mistakes are also said. My lord, kindly see. Whereas considering the national as well as state interest of the program and its smooth functioning in the interest of public service, release of the applicant for long 3 years will create an inevitable difficulty in the administration. And this is after your lordship's order. And my lord, already my lord, my head, they have recommended that yes, I can be transferred. There is no administrative problem in it.
That recommendation is of 24.
Yes, my lord. Yes, your lord. Yes, yes. I'm grateful, my lord. That is at page, my lord.
But after that, one person has retired.
One person has retired,
After
one
that,
joined, and now, my lord, there are 2 persons. Your lord.
after that, you are not obeying your officer's orders.
My
And
lord,
you want a leave.
my lord, actually, what has happened, my lord? They have directed me to join, my lord, BLDO. That is a complete separate post. At the time when the tribunal told to consider my application. So, my lord, I said that it is a different post. It is not my. I am a veterinary sergeant, veterinary officer, and that is a BLDO is a completely separate post. Then, my lord, one BLDO has joined there, and my lord, there are 2 veterinary officers as of now. I am one of them.
For such person, whether we should exercise our jurisdiction. He is too big for his boots. He is given a direction to join a particular post. He
Yes,
does
my lord, I
not
have joined.
care. No, you have not joined.
Yes, my lord,
Where
I
is
can.
that statement?
My lord, I
That
can.
you have joined this post? Show
No.
us.
My lord, I am there in this post only.
No, sir. Please have a look.
My lord, BLDO is a separate post.
Whatever it is, can you just sit on the order?
My lord, may I just show the. My lord, that was considered last time.
That's not the matter before us. That is not the substantial issue before us. That is not raised by you. You think that it is not a post for you, you will not join. Can this be encouraged by any court or any forum?
My lord, on last occasion, my lord, I have also shown those documents. My lord.
Maybe.
My lord, these. My lord, let just kindly say, have a look.
That's not the issue here. Such a person, now they have taken stock of the manpower. They say these schemes are required to be executed. You have no right. That 2 years hardly makes any difference. You see the first paragraph of that order. That obviously it's a typographical error in the 3rd line of the first paragraph. They know that you are seeking 2 years. You see the first paragraph, 3rd line.
Yes, my lord.
You cannot force them to give you a study leave.
2 years. On the object of the completion of PhD. I don't know. This, my lord, your lordship see the original order. My lord, it is annexed in this writ petition.
Which
As well as-
original order?
That they are saying me to join one post and I did not join the allegation which has been made.
See, have you, because you have filed an OA,
Yes.
in that way, have you said that this is
Yes,
a wrong
yes.
recording? I have joined that post. Just show that averment. from
No,
your order.
we have not joined, my lord. When that original application, my lord, may I just explain, my lord, subject to correction. My lord, I was told to take the charge of BLDO. Now, so far, block livestock development officer, and I am a veterinary officer. My lord, I cannot take that post in my rank. Then I indicated them. Subsequently, another person by way of an order came and joined. It is not that I said that I did not join. I said that my study leave is under consideration. That is a
That is what we are finding.
my lord, that is a
Just
separate
because
post.
you have applied for a study leave, that does not give you a right to go on
My
leave.
lord, that is already that is a separate post, not of my cadre.
It's not the issue here. That's not to be looked into or adjudicated in these proceedings. If at all that was a grievance genuinely felt by you, you were required to take recourse, not sit on the order.
No, I did not sit on the order. I immediately approached
Therefore,
the
we have
department.
asked you in the OA, have you said that this order, this reason is wrong? It
Yes,
is
yes,
false
yes, yes.
because I have joined the post of block livestock development officer.
Yes. My lord, kindly come to page 126, my lord. Like, it is all are there. My lord, kindly see 124 was the page 124 was the order of the tribunal for reconsideration.
No, where is your OA? What have you said about this order? Why is it bad? Let us see.
Well, may I just indicate the annexes, then I'll come to the affidavit.
In the reverse.
No, my
If
lord.
you have made a pleading,
document.
then we'll look into the document, or we'll look into the document without a pleading.
Well, pleadings is there in the
So
original.
show the pleading first. Unless you say so, what is it to what the document is going to support?
My lord, page 58, your lordship may kindly see. My lord, the pleadings is there. In the original application, your applicant states that the concerned respondents, while past, may I just read it out? 58.
No, you are talking about the order. Now you come to page 50, paragraph 18 and 19. This is what you have done. You have said, I will not join because my leave is under consideration. That is your specific averment in the OA.
Page 50. কোন জায়গাটা বলছে?
As of today, what is the situation?
মানে
This order was passed when?
shortage of staff is there.
November. We are in February. Find out if you can let him go.
Can you see page 143? Whereas making 143 internal page 2 of the email order.
Sir, we have read the entire order. We have read the entire order. We have seen. You say that he is to enhance, he is to serve the public purpose by performing these duties.
Yes.
That is all right. But he's saying that there's somebody else has joined, somebody is there to take care of these things. We don't know when he has joined. What is the position? You take present up-to-date instruction, see what can be done. Let opposition.
Well, actually, what is the condition? That was a separate post. That is why I said them, they have recalled the order.
No government servant can do this, and no court will encourage anyone to do this. Please try to understand what we are saying. You cannot justify these things.
I can understand what has fallen from your lordship.
Not justify these things. There has to be. We know we can't certify all actions to be.
Item number 4. Service has been completed in respect of respondent number 3, but a GP service has not been completed, my lord. This says that leave is required.
What is the issue? Let us see.
Well, the issue is that, my lord, a transfer, I am a government school teacher.
Very good.
One transfer order has been passed in my favor.
Yes.
Then, my lord, I have not applied from Kolkata to Jalpaiguri. They said that yes, you have applied. They said that now online you have applied on that on that transfer.
Where is the document?
May I? Thereafter, my lord, there was a partial modification of that order. Transfer of some person has been, my lord, restricted or restrained by them, my lord. And that document I also want to, my lord, just before your lordship, my lord, transfer order before your lordship is page 14, my lord. Sir, my name is appearing is page 22. Serial number 22, my lord. Thereafter, my lord, thereafter, my lord, I have page 23. Is 22, 23, I have prepared them. In the meantime, my lord, I have been appointed as BLO. For that reason, my lord, I cannot take charge, join there. Lord, thereafter, my lord, page 26. SDO has passed an order that not to give effect of that transfer order. Page, annexed P6, my lord, page 25. Can you have a look on this? Page 25, my lord. And my lord, till commencement of election, I cannot there, my lord, I cannot join because of the fact, my lord, that
So you join after that. We'll record that you will join after that SIR is over.
SIR, my lord, thereafter partial modification of that order. That
Nothing like that across the.
my lord, yeah, not on that, my lord.
If it is in the record, show it. Otherwise, we will not take any document like that.
My lord,
If it is in record, then show it. We are not going to take documents like that.
my lord, I will file, my lord. After that, my lord, I have received that document.
What have they done?
They did a partial modification of their order, transfer order.
How it affects you?
But, my lord, I have applied there. I have not, my lord, my
How that partial modification affects you? Tell us. You have already said I have applied and they have asked me to insert that I have opted for Jalpaiguri in the portal. We are hearing everything. How does that affect you? We are asking you.
because, my lord,
How that partial modification is relevant to your case? That is what we are asking you.
But because some other person has been allowed to, their transfer order has been changed.
Very
They
good.
remain their said post. But
Maybe.
my application has not been
So
considered.
what is the right? What is the right? What is the right that you are espousing? From 2002 to 2013, you were at a particular pace. In
Yes.
13, you came to Kolkata.
Yes.
Now you say the chance of my children's education is good. So therefore, I will not go anywhere. It will cause hardship.
Jalpaiguri, but I have not applied. I am ready, but I have applied before
So
them.
we are asking you, where is the right that you will be transferred to only a place for which you have applied? Please show.
Right means, my lord, I have applied. I have written a letter, my lord, to them.
So for 13 years you are in Calcutta, therefore you should not be transferred. This is the substance.
Vacancy.
This is the, there may be vacancy. Why only you? Why not others?
My lord,
Your hardship is above everybody else's hardship in the department.
my lord, it is kind of mercy petition. It is not relating to, my lord, kind of mercy petition.
Can we exercise a mercy jurisdiction?
That is up to your lordship, my lord. I am
Very
not
recent judgment. Very
I
recent judgment.
know about that. I know about
How
that.
we can
but
exercise a mercy judgment, jurisdiction?
May I come back on?
You'll come back for what, sir? We are asking you, where is the right? that once you have made an application, they are obliged to consider your transfer to a particular post. In a-
Only one thing I am saying your lordship, let them consider personal decision order.
No, you are not complying. You are not doing anything. Since October, you have been transferred. You are not going to encourage such persons.
No, I have applied, but that has not been considered.
For 4 months, you are sitting at the place, not joining the transfer place.
Yes,
such a-
after that, October, I have been appointed as BLO.
So did you write to them that because of
Yes,
this?
yes.
Where is that?
Yes,
Where is that?
yes,
After 4th November, what have you written?
yes, I applied. Malad, 30th October, I have written there.
We are asking you after 4th November, what communication have you made with your superior authority, relying upon the subdivisional officer's order?
Case 6 minutes, subdivision officer order, I have. Thereafter.
What is the date?
Date was on 4th, 11th.
So therefore, what have you done after that?
After that,
The
but I
third
have-
time we are asking you.
Yes, Malad, I will show you lordship, Malad, on next day, but it is with me, Malad. I have applied for.
Not today.
No, not today, Malad. For service, Malad, I have to take, Malad.
We don't require service. You are not, service is not a routine way.
Malad,
We may dismiss it without any
Malad,
service.
Make it on 17th, Malad.
No, sir.
Make it on 17th, Malad. Tomorrow I have, Malad, I cannot, otherwise.
Come on Monday.
Monday.
Yes. It's not coming tomorrow. Call the next.
No, Malad, only 17th, Malad, I have. Only 17th.
All right, as prayed list on 70.
Item number 5.
My lordship, I am for the petitioner led by Mr. Dilip Kumar Sinha. I am praying for not this week, my lord.
Why, sir?
He is suffering fever, lordship.
We are informed that Mr. One week? No, 1 week will be 23rd. 1 week will be 23rd. How you are saying something?
Item number 6.
Lordship, this is my appeal, or Lordship. I am led by Mr. Amol Sen. There is a sudden medical emergency back at his home. I am indebted to my learned senior friend, the other side, your Lordship.
Next week.
Lordship, as my learned senior friend says, your Lordship. As your Lordship pleases. And apologies for that.
No, no, a medical emergency. Why should you apologize?
This was very sudden.
Yeah, members, we do not stand.
No, any member, if he is having a medical emergency, what is to be done? A lawyer is also entitled to difficulties. Yes.
Item number 7.
7, I am appearing on behalf of the respondent, your lordship. My lord, I am being led by Mr. Kaushik there. I am only playing for a week's time, your lordship. He was informed he has got some difficulty. He has
As jointly prayed, 20. Matters not only to be adjourned. What is the problem?
1 week's time, your lordship.
No, has it been adjourned earlier or this is the first time?
No, my lord, it was adjourned earlier also.
No, 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 please. No, don't do this. This is the third adjournment since December. Let us see what it is.
I'm only
Why it is pending? What is the issue? We are not going to pass any order. Not today. It will come on the next date for old matters. Yes, not today.
Okay. পরের দিন
Item number 8.
Item number 8 and 9, my lord, is a state appeal arrived for the respondents. That matter, your lordship may recall, where, my lord, the tribunal passed an order with a further rider that if the proceeding is not been concluded within certain time, my lord, it's ex parte, it will be in default, the proceeding is vitiated. Now, my lord, against that, they moved the writ petition against an MA application was filed, extension was filed. That
By
was
application
after
or
the date.
I think the respondent has not filed.
Just recapitulating, my lords.
A departmental proceeding initiated against staff of a government of West Bengal,
What post was he holding at the time of the initiation of proceeding?
Group A officer,
Group,
A officer,
Group A officer. What post?
Sub-assistant engineer.
sub-assistant. But initially it was Group B because of the change of scale of pay. Now it is
So what is the date of the punishment order?
one of
16/1/2024.
no. One of the second show cause
Mr. Rai, please. Yes.
second show cause notice issued on 20th August 2018.
20th August,
August 2018.
second show cause.
Yeah. Then Malad, after second show cause notice, when he is a PSC staff, matter has to be referred to the PSC for their opinion under the rules. If there is a PSC staff, PSC's opinion is necessary.
Oh.
Then 15th September 2019, Principal Secretary was informed that proposed decision has been taken by the government for punishment of the particular employee. Then
What punishment did you propose?
proposed one initially withholding of increments after conclusion of the department process. Then
Holding of how many increments? Major or minor punishment?
two incremental increments.
With cumulative.
Two incremental measures with cumulative effect. Whatever may be. 15th October 2020, an application was filed before the tribunal.
Yes.
22nd December 2020, the tribunal disposed of the application directing us to conclude the dispute proceedings within 6 months.
OA number?
OA number 406 of 2020.
Yes. To dispose of within
Within 6 months.
6 months. Yes.
My lord, in the meantime, the lordship knows that COVID started in March 2020. And my lord, our 5 judges bench extended all the period tribunals up to 28th February 2022. That order was passed on 23rd February 2022. 23rd February. Justice Chief Justice Sibagnanam, Justice I.P. Mukherjee, Horiston, Justice Tapabrata Chakraborty. We can excuse me, I have got one. I complied the Supreme Court's order. In compliance of the order of the Supreme Court.
which is annexed to the
Which is annexed to the writ petition.
বিবৃতিও নেই আমার ক্লার্কও নেই এরা সব মতলব মারা হাসবে এদের সব হোয়াটসঅ্যাপে দিলেন আমি সেই জন্য কালকে বললাম যে যদি আমাকে আনতে হয় আপনি একবার ফোন করে দেবেন
আমার প্রথম মনে ছিল আমার মেশিনটা কাজ করতো না প্রিন্টারটা
আচ্ছা
তারপর বন্ধ
Yes.
The 20th December, 22nd December 2020 order was passed by the learned tribunal.
22/12/20.
20. Malad,
And this
because
order is of which date?
Malad,
This order that you have given us is of which date?
22nd December 20. That is page, page 54 to 50. Malad,
What is the date of this order?
most probably February
Yes,
2020.
23rd February 20.
And Malad, page 54 to 58 order of the tribunal to complete the proceedings within 6 months. Then Malad, since he is a retired employee of the government, under Rule 10(1)(a) of the West Bengal Death Crime Retirement Benefits, consent from the governor has to be obtained. We sent a letter on 28 January 2021. That is at page 74 of the petition. What is the word for it?
This covers what period prior to passing of this order? This order is passed on 23/2/22.
Kumar.
It covers which period prior to this order?
From March 2020, 24th March was a declaration by the central government under the Disaster Management Act 2005.
Yes, that is the day national lockdown was imposed.
National 24th March 2020. Then on 28th January 2021, governor was approached to kindly sanction this. The gentleman has retired from service, sanction is necessary. When no reply came, then only we have got a remedy to give a reminder to the secretary to his excellency on 19 May 2022. Then we filed an application for extension of time.
19th May 22.
First 28 January 2021.
Yes.
And a reminder on 19th May 2022.
Where is that?
That is page 74.
19th May 22.
2022. Thank you. No, it's a if I have committed a mistake.
But understand, whether I'm saying anything mistakenly, let him complete, my lord.
Then 13 July 2022, another letter was issued to His Excellency, His Secretariat. Page 75.
Yes.
Then we filed an application for extension of time to complete the proceedings, because proceeding is completed, inquiry has already been held. But on second circus notice issued, only communication of the final order. Final order consequence, if governor approval is granted, then we can communicate final order. Because in the meantime, he has retired from service, only punishment, curtailment of pension.
Till date, no punishment has been awarded.
Pension has been awarded. That has not been challenged.
Punishment has been awarded.
Awarded by His Excellency approval.
By which order?
Well, kindly see, that is at page. Supplementary affidavit, kindly see. Kindly see the supplementary affidavit. That page. Page 7.
What is the date?
Date of the order is 16 January 2024.
24.
24.
So that is the date on which he has been communicated the punishment.
Commission. After the admission grant stay by this honorable court, in the meantime, got
There
a,
was a stay.
no, there is no, there is an order passed by this court. Can't you see the order? Just,
No, you said there was a stay.
no, there is an order passed by this honorable court.
What?
But so far as governor's approval is concerned.
What order?
My lord, 16th of January 2024, my lord, the governor passes an order. My lord, they filed my lord, a supplementary application wherein the order was, my lord, annexed. My lord, that
Before
was
the tribunal?
before this honorable court. My lord,
Before
when
this
the
court.
writ petition was pending. My lord, matter came before the honorable court, my lord, coordinated bench of this honorable court on 30th of January. My lord, at that point of time, I'm not getting anything, either my pension or
13th of January.
30th of January,
30th.
my lord. And I was not neither getting my pension, my lord. I will only getting the provisional pension. My gratuity was withheld. My leave salary was withheld. Everything was withheld. My lord, at that point, juncture, my lord, as condition of mine is such, my lord, I'm compelled to say this before the honorable court that I'm practically starving. At that juncture, my lord, the honorable court said, leave apart that 20% pension cut which has been awarded, release all the other
Pay
benefits.
him all right.
My lord, even that, my lord, with that point, my
So
lord,
effecting the punishment, you make the payment during pendency of the writ
Yes.
petition.
petition, and thereafter, my lord, it came before lordship, my lord, after that.
Then only remedy available, reduction of pension. Because punishment which was initially affected, that could not be imposed, then only 20% of his pension. Order গুলো কইছো? ওই যে তিনটা আছে। আমার মেশিন খারাপ, দুটো মেশিনই খারাপ হয়ে যাচ্ছে। আচ্ছা, আপনি যা বলবেন আমাকে যদি একবার যাদব ইমেলটা কবে ফাইল হলো দেখতো, ইমেলটা কবে ফাইল হলো?
So even if we consider this order
আমার
and grant you the benefit till 15th March 22, then why it has taken you more than 2 years? Roughly 2 years.
no, kindly see,
So how this helps you?
but during the COVID period, that period should be extended in the last
So the last date for that extension
Up
is
to
15th
February.
March 2022.
we have 28th February 2022.
Anyway, all right, 28th February 22. Then after that,
After that, but in the meantime, time lapse, he is retired. Approval for the governor is necessary under Rule 10(1)(a).
then it cannot be sustained.
Then the London Tribunal said I become functus officio. That is at page 94, order dated 6 September 2022. That MA was dismissed. Page 94, ordering portion at page 95. Inquiry was completed. Only final order could not be communicated because final order has to, only final order.
Until that order is served, what good is your inquiry? It is worth nothing.
Inquiry report was there.
It is worth nothing.
Second show cause notice.
What
Then
you are saying
only
only.
what is the decision? Subsequent decision. But
If that is the attitude with the authorities have proceeded, that only order is to be passed, that is why this has happened. If they had understood the importance of passing the order, this would not have happened. What is this? How this order helps you? You are, even if we allow you the shield of this order, it is till March 22. 2 years thereafter. 2 months less than 2 years.
No, but kindly see,
Absurd. You have never challenged the order of the tribunal.
no, we have only prayed for one extension of time.
When did you file the extension?
Extension of time filed on 24th of August 2022.
24th August
2022.
22.
And that was rejected on on 6th of September 2022.
The fact remains. What is the extension you sought? The MA. What is the MA number?
Amen. Just 1 second, madam.
You must have filed a miscellaneous application.
Yes, MA number. MA number 98 of 2022.
Where is that? At which page?
On the last, impugn order at last page. Page 94.
No. Where is the MA?
MA starts at page 78. Ends at, prayer at page 81. Under the circumstances, paragraph 4. Your applicant said that due to the nature of the COVID-19 pandemic, the works with regard to the instant case was delayed without any fault upon the petitioner. That by letter number dated the Deputy Visiting Auditor to the Deputy Governor, Governor Secretariat, Raj Bhavan, Kolkata, enclosing a file the instant case to expedite the process and to conclude the DP case, and also later by letter number 17 March 2022 from the Deputy Secretary Vigilance Public Works Department that to the Secretary to the Government of West Bengal, Governor Secretary Raj Bhavan, Kolkata, enclosing a order dated 22nd December 20 to expedite the process for obtaining the sign of His Excellency the Governor of West Bengal in the matter of proposal of penalty to be imposed upon the respondent. Then thereafter, that as the matter is pending before this announcing, therefore it is not possible to comply the order dated 22nd December 20. It is to extend the time for compliance order and member of judicial court to another 6 months.
Seeking extension. 16/120. And where is the 16/124 order?
But that is at internal page, page 7 of the supplementary agreement. Annexure C. First discussion about the charges. And governor's approval only 20% of the pension, nothing more. Only for 5 years. কি বললেন? কিচ্ছু বললেন একটা হোয়াটসঅ্যাপ কি পাঠিয়ে কি বলি কি একটা
What did the tribunal hold?
Madam, in the first matter, the rejection of the application, holding that I made a functus officio. Since original application been disposed of, I cannot. And second one, then again he filed another original application. Since 6 months time has elapsed, I may be granted all benefits without any deductions. That application was allowed. That we have also challenged. That is also
No, the MA order you have said.
yes, two writ petition. Order passed in a miscellaneous application and order passed in the original application.
So right now we are considering
Two writ petitions.
both are filed by the state.
Yes.
And where is the order passed in the OA after this MA?
That the second matter. First or page 55, kindly see page 55. Here. Ordering portion at page 57. Had the parties and produced the records, noted the charge sheet was issued as per back on 16th August 2018. The second shock was notice already issued on 7th of June 2018 against the applicant. He submitted reply on 12th of July 2000. Therefore, we direct the respondent to conclude the departmental proceedings within a period of 6 months and to take a final decision by passing a speaking order, a written order as per rules. Communicate the same from the date of received order. In default, the proceedings should be initiated according to wage disposal of. In the page 61, the communication to the Public Service Commission, 20th August 2018. And kindly see page 65, PSC reply, 12th of September 2020. And page 65, PSC's order was not challenged. PSC opined that 20% of the pension benefit for a period of 5 years.
Yes, which order not challenged?
What?
Which order was not challenged?
The final order passed by the government, that is 16th of January 2024. Passed by the government, and the order page 65 passed by the Public Service Commission approving the second show cause notice. Penalty. Page 65. I'm directed to refer to the public department number 20th August 2000 and subsequent correspondence relating to department data number such and such. Noted above state that after careful consideration of the records as forwarded to the commission is the opinion the charge officer is guilty of all the charges framed against him. As regards his penalty, the commission having considered.
Page 65 is part of the representation dated 12/7/18.
Yeah.
In WP 118.
WP number 118.
Just now you said second writ petition, now you are referring to
No,
the
no, no,
first.
no, this is the first petition I'm just. Page 65.
How he will challenge a intra-authority communication?
No, no, we have not challenged. He has not challenged.
Why he should challenge? How is he prejudiced by this?
But this is a approval by the PSC.
Maybe,
Approval by the PSC.
maybe. Which other document you are saying?
Then, Malad, we filed it. After that, order was passed by the tribunal to complete the dismissal proceedings within 6 months. Could
Yes.
not complete. Prayed
Not
for
after that, much before that. The tribunal's order is prior to this recommendation.
no, no, tribunal
Oh, after
order is
that, yes, 22/12/2020.
Yes,
Yes, after this. So
after this tribunal.
therefore, where is the question of challenging this? This is covered by that order of 22/12/2020.
Assuming for a moment that entire thing is covered by the to complete the dismissal
Yes.
proceedings. Yeah, within 6 months, we could not complete the proceedings because of the situation. We filed an application for extension of time. The tribunal rejected the application on the ground that I became functus officio. Tribunal became functus
So
officio.
once it was rejected, could you proceed?
But that we have not proceeded by His Excellency granted.
Whoever has proceeded under the CCS or your WBSR, can he proceed in violation of the tribunal's order?
But that's why we have moved the application, but that directed to
What
grant
direction?
pension.
You have no regard for the tribunal's order.
No, on that where, but this
Whatever
order,
tribunal says, it may say, I will proceed in my own way.
no, but this order passed by His Excellency.
Whatever order, don't repeatedly use that expression. That is not going to help you. He is not enjoying any immunity in these powers while exercising jurisdiction under WBSR and CCS and
As we
as
put
a
more-
chancellor, there is no immunity.
no.
Those orders are subject to.
Yes,
The law is
some-
very well settled.
But the order passed on 16 January 2024 has not been assessed before any court.
Correct. What is the sanctity of that order passed in violation of a court's order? We are asking you to show the law.
But whether
Any order passed in violation of the court's order, in the teeth of the court's order, how it is to be treated?
we have not violated the order, court's order. We have, but kindly complete the.
So you have complied.
Complete the inquiry. We have completed the inquiry.
Wonderful submission.
But-
You have not violated, you have just completed the inquiry. So you complete the inquiry, keep the order with yourself.
But
How he can be affected by that?
final order could not be communicated because of the rule 10(1)(a).
Rule?
10(1)(a) of
What
the
is 10(1)(a)?
of the West Bengal death and retirement benefit rules. When if somebody retired from service, then the proceeding from CCS rules to the go to the.
Whatever it is, you have to do it.
Kindly see the language.
not-
in rule
What
10(a).
is the tribunal's order? There is nothing wrong with the tribunal's order.
Whether he is
No case.
whether he is a functus officio or not. Malad dispose.
How it is functus officio?
Yes, Manad. If Manad passed an order disposing an appeal or a petition, pay 5 lakhs to the person concerned within 4 weeks. Manad, for any reason, the government could not pay 5 lakhs to that. Then what is the remedy? To apply before the court, to exercise the power, to extend the time 4 weeks or 2 weeks, whatever may be there. The court can extend the time. Court has got inherent power. That has been discussed by Justice Datto in a recent judgment placed by Learned Friend. In that case, when a departmental proceeding was initiated and when a departmental proceeding was set aside by the
If there
tribunal,
is the tribunal also has the power to review. There is no dispute that the power does not have the power to review.
but we have review of the main order. We have what extension of time.
Anything, it will be in the exercise of same power. If a court has a power to review, then only it can review, recall or modify or extend.
No,
Otherwise, how it can do it?
extension of time, Malad, but only normal application here, civil court or high court, 151 or 152.
Therefore, we are saying it is an exercise of inherent power.
Inherent power of the.
So that, and if a adjudicatory body is a statutory, then review power has to be conferred by the statute.
Yes.
Here the review power is conferred by section 22(3)(f).
Yes.
So therefore the tribunal had the jurisdiction.
Then-
You did not invoke the jurisdiction within time. You allowed the time to lapse. You had 3 months prior to the restrictions and then you had 5 months after that. You have not done anything. And you have passed the order 2 years after. As if you can take all the time in the world.
No, certainly, madam. Madam,
And
consider-
you are here challenging the tribunal's order. So even if it is not functus officio, let us take for a moment that it was not functus officio.
Madam.
Then what is the ground for extending the time?
Madam, number one, number two, unless this governor's approval is granted, we cannot.
How many times you will say that?
No,
You have
first-
sufficient number of times you have said.
This is the first one.
Yes.
And but so far as the.
So
study-
therefore it can wait till 10 years also.
No, certainly not, with a reasonable time.
What is reasonable? Not as per your notion. Reasonable as per the order already passed. If
Already
no
passed.
order is passed, then reasonable as per your notion.
Madam,
Once an order is passed, where is the question of reasonable? If the tribunal's order is not considered reasonable by you, then you will violate it.
No.
Very nice.
No, we have
What
not.
kind of submission you are making?
Violated the person intentionally. We could.
Where is the question of intention? You are a
No, no.
government. You are a government. There is a violation. Where is the question of intention? You are not an individual that one will look into the intention. If you are individual, then one will look into whether you were prevented by sufficient cause, you had any malified mens rea.
The tribunal
You are
rejected
government.
on the ground.
He is not alleging malified
Tribunal
against any
rejected on the
individual.
ground, functus officio. Whether tribunal is a functus officio or not.
We are saying even if we set aside what relief you will get. We are considering now.
Madam.
You tell us. Forget about functus officio. We have seen that the tribunal has power. We all know the law. 22(3)(f)
Yes.
section, there is a power of review conferred on the tribunal. Once the power of review is conferred on a statutory authority, it can review, recall, modify anything.
Yes.
Now it has not done it.
Done.
The reason may be not to your liking. Even if that reason is set aside, we are looking at your bona fides. Look at this. You ask for a 6-month extension and you take 2 years.
Madam,
And then you are saying tribunal has said this, tribunal has said that.
no, madam, if that application was allowed, then order could have.
Then
been-
you would have done within 6 months. Otherwise, you will take 2 years.
No.
Very good submission.
Madam, if the application was allowed, then within 6 months.
Within
could have
6 months, you would have done it.
been- Yes, certainly.
Certainly. And because not allowed, therefore it can be
No.
done in 2 years.
No, but 6 months, madam, we have.
You have
madam,
no case.
We have sent a letter to the.
You
competent
have no
authority.
case.
And madam, the judgment relied on by my land fund 2025 basis. See, madam, the issue of the judgment, madam, kindly see for a moment. My land fund press 2025 SSC online page 891, state of Uttar Pradesh, Ram Prakash Singh.
Ram Prakash Singh, yes.
Yes. Madam, kindly see paragraph 2, Roman 15.
For what? To show what?
Madam, to show that if an order is passed by an authority, disciplinary authority, after the completion of time extended by the tribunal, that order is a nullity. Then, madam, considering all this one, madam, first, madam, 15, 3
If it
months.
is a
time-
nullity, then you are out.
No, madam, now it has been answered.
Yes.
Answered. 3 months period stipulated by the tribunal for contradictory inquiry expired on April 2024. Madam, kindly see the issue framed, issue number 7, Roman 4. Whether inquiry not having completed within the time stipulated by the tribunal, order dated 14 July, the disciplinary authority procedure could not have continued later. But here the inquiry was not.
Where is the answer?
Madam,
We have
yes.
understood what you are
Yes,
saying.
answer I'm giving. Answer is at paragraph 61, 62, 63, 64.
Come to 62.
To 60
In exceptional circumstance, if
Yes.
for some reason it has been violated, it may be considered.
Yeah, but kindly see 61 first.
So therefore, we are asking you today, what was the exceptional circumstance that you prayed for 6 months and you took 2 years?
But
Even if, see, the entire matter is before us today.
Yes,
We can allow the MA also today.
yes.
Your conduct becomes relevant. Forget about whether it could have been done or it could not have been done. You will take all the time in the world.
But can the
Government means this.
No, no.
You have seen the recent judgment. You don't have that government that it is presupposed that there is some lethargy in the movement of files because there are so many officers involved, but this does not mean that you will derive a premium from this concept and you will take all the time in the world
No,
to
no.
do whatever you want.
But if the action.
62, read 62. You are placing
Mana,
62 in exceptional cases.
Page, paragraph 61, question number 1B.
Yes,
Last sentence.
yes.
But the judgment of the Supreme Court quoted that the court has inherent jurisdiction to grant extension of time, the original stipulation of time having been fixed by the court itself, such extension of time has to be considered in the interest of justice, balancing both the need for the expeditious conclusion of the inquiry in the interest of the fairness and the honest administration.
And an honest administration
And
in
then
an appropriate
in
case.
an appropriate case, it is
Correct.
open to the
That's
court to
exactly what we
decide.
are saying.
Suo motu.
Yes,
Suo motu in regard to the ensure that the serious charge of misconduct
correct.
does not unpunished leading to serious detriment to the
Correct.
public
There is not,
interest.
there
The
is,
court has
this
sufficient
is a very,
powers to grant extension.
very
of time.
well settled principle.
Then paragraph 62.
Yes, in exceptional cases,
While affirming the aforesaid view of the full bench would like to
depending upon the cause shown and the cause for inability.
Yeah.
That is what the court says, not because you are government, it has to be done.
No, but
Depending on the cause shown and the inability. You ask for 6 months and you take 2 years.
no, but
And this is a bona fide action.
if I communicate the order without the approval of the competent authority, can the order be sustained immediately? Set aside?
Then you would have filed another application for extension.
No. If
No. You are not required to do anything.
we cannot assume anything, which is.
You are assuming that what if we cannot get approval, then what will happen? If you cannot get approval, you will file another extension. You will not sit because I am government, I can do it in 2 years.
Kindly consider, can a secretary or a deputy secretary?
We don't know. That's not the issue before
Issue
us.
But
The thing is that secretary will not sit idle. He will approach the tribunal that look, it has not been done till now. Extend it further. He cannot take shield behind all this. Government infrastructure.
We are waiting for approval.
Keep waiting. Why you did it in 2 years? You could have waited for 5. Why did you do it? What was the rush that it had to be done in 2 years? You keep waiting.
Until the approval comes.
You're not making any sense.
There is a precondition of the rules.
Yes.
Rule
That
has
is your
come by-
rule. You know about it. That's not it is not coming in between exercise of power by you. That is your rule. You know that these things are going to happen. Consciously, you ask for 6 months. Can't be. There is no, you are not able to make out any case.
That's why the basic should, even after expiry of the statutory time, such an application can be moved and depending upon the cause shown for the individual failure to conclude the proceeding within the time stipulated also for not applying for extension before expiry. The tribunal may in discretion may allow or reject the prayer for extension.
So it has,
Then-
we are in agreement with you to this extent that maybe prima facie the tribunal's order saying it is functus officio, whether that could have been sustained or not, we don't. Subject to what they say. Maybe they will show some law. But even if the tribunal was to exercise jurisdiction, there is no material, nothing. And today you are not able to show any bona fide in your conduct, in the way you have pursued the matter. You have taken your own time. It
No,
has
but I
happened
have
in
not
2
taken-
years.
But that power not was
You
vested.
cannot divorce yourself from any authority.
But
You
I-
are you.
But the state government,
You are you, sir.
state government, there is executive
Yes.
and but the constitutional post holder.
Yes.
There is a difference between them.
Yes.
But
You cannot take shield.
we cannot ask the governor.
You cannot take shield. If you cannot ask him, you could have asked the court or tribunal that please extend further. We are waiting. We can't do anything. Then this argument you could have said. Not after waiting 2 years.
We have also mentioned that. We have also mentioned in the original application. Paragraph 5. Paragraph 5. And there is no denial to that fact.
Very good.
Paragraph 5 said that has been under Rule 10 you complied, file has been forwarded to the appropriate authority. This has not been considered.
What is there to consider in this?
Murder.
What is there to consider in this?
Murder.
You will say, I have done this on this date, I have done this on this date, I have done this on this date.
Murder.
What is there to consider?
Consider.
That is for the
that-
court to
that is
see
for extension of the-
whether you have done something in accordance with law or you have taken your own leisurely time.
But
That
we
is
cannot,
for us to see
But now-
what they will say on this.
but we cannot pass any order until unless the rule approves it.
Yes, who is saying that you pass it without approval? Who said?
Madam,
Anybody is suggesting that without approval you should have passed it.
No, madam.
Then
Madam,
why,
that's
why
what-
this
i-
argument? That
i-
is what we are not able to understand.
But the only difficulty is for the state government, until that approval comes, whether order could be communicated.
Surely not. Then you should have waited a decade at least. Why did you rush in 2 years? That is what we are trying to understand. What was the big hurry in 2 years? Why not 10 years?
When as soon as when court directed us to pay the
There
pension,
was no rush that it
then
had to be done in 2
immediately
years.
file was placed before got an approval, then he has been paid.
Why this rush that get approval within 2 years? Why not 10 years? What you are submitting, we have understood.
Can you see them?
You are not answering our question. You are only saying this rule does this and this rule mandates this. We are not on that. Nobody is asking you to violate the rule. Neither they are not the court has asked you. You have consciously approached the court saying, I will do it in 6 months.
Yes.
And taken your own time for 2 years. Not even bothered to go back to the court.
No,
That
we have
look-
immediately approached. This
No. After that 6 months, you have not approached.
No,
not
before
done
6
anything.
months, we approached the competent authority.
No, you have not. You have approached in August 22.
Just
You have
give-
filed MA 98 in August 22.
Just 1 second, minute.
On 24 August 2022. Come to the affidavit verification page.
Page 74.
Not my turn, my lord. The tribunal's order rejecting the MA is of 6/9/2022. Well, they approached this honorable court on 17th of August 2023. Again, more than 1 year gap.
More than 1 year.
Filing this writ petition.
What can they do? Their rule says it has to be done in this way. That is his argument. My rule says like this.
On page 74, 28 January 2021.
I have to seek his approval. I have to seek his approval. So what is the matter if the tribunal has passed order? Nothing. I have to go as per my own convenience.
But have I got any
In
power?
substance, this is your submission. You have no power. You still seek an extension for a time, you knowing that you have no power. And after that, you do nothing.
And as soon as the
And
court,
you sit over the order for 1 year, then you file writ petition. For all this, somebody else is to be blamed, not you. Height of administrative lethargy. This is the height. And in the face of an order of a competent forum,
yes,
which is binding on you, unless it is set aside. This is the
But-
conduct.
but the order of the competent authority under Rule 10(1) has not been challenged by anybody. And we have paid pension according to the order of the court. Now he will get, if my lord dismisses the application, he will get full pension.
Whatever you have paid, you have not done him a favor.
No.
You have not done
But
anyone
if,
a favor.
but if matter is
You are bound to do it.
no, but if under the rules, if matter is pending before the subjudice, the court normally the department does not sanction except provisional pension. Final pension is sanctioned as soon as matter is over.
No, that is because you have all the power to do whatever you want. Is there any rule which says that if a matter is sub judice, only provisional pension is to be paid?
If department proceeding is pending.
No, you just now said that if any proceeding is pending.
Proceeding, that means possible.
So
if
where is that rule which allows you to make only provisional payment if a proceeding is pending?
Rule 14 to the
There is no such rule. Unless there is an order of the court, you have to make the payment.
Rule 14.
Rule 14 na 10 to 10 to
Can you see the rule 10 to
10
That is something else. That is for criminal case.
criminal case.
But
Judicial.
in the departmental proceeding instituted under subject 1, where department proceeding is continued under the proviso of the retired or attending supervisor Otherwise shall be paid during the period of corresponding the date of determined to the date of which consequential proceeding the final order passed, a provisional pension not exceeding maximum pension which have been admission on the basis of qualifying service up to the date of retirement if he was under the suspension on the date of retirement up to the date of immediately proceeding the date on which he was placed under suspension, but no gratuity or death of retirement shall be paid to him until the consideration of the proceeding and the issue of the final order.
That's not the issue here. You are saying that I have paid the pension due as if you have
The
done
pension and
something.
other benefits.
Then
As per order of the
that
court.
is not the issue. Why you are reading that?
As per order of the court.
Does not apply here. That's what we are wondering why you are reading that. Once the order has been passed on 16/1/24, how it applies? After that, how it applies?
After that order, when the petition was admitted, that order was passed by the honorable court.
That was not required. You are supposed to pay on your own. There is no rule which says that once a punishment has been awarded and the amount which is admissible even after that punishment you will not pay because the person has filed some case. Is there any rule?
Kindly see.
What kindly see? That is for departmental proceeding.
Departmental proceeding.
Don't know whether you are able to understand us or not, we don't know. We are asking you something, you are saying something else. Any petitioner, if he approaches the court, there
As
is
soon as the final order has been passed by the competent authority, pension payment, after deducting pension, everything has been paid.
when did you start the payment? Let us see your bona fide on that point also.
After order of the court.
Yes.
2020-23.
No, your order is of 16/1/24.
Yes, sorry.
So after 16/1/24, when you have made the payment?
Continuously paying.
When did you start making the payment?
My husband can say.
Well, after the court 30th January order, my lord.
30th January?
2024. Well, when the coordinated bench passed an order to release all the benefits, 7 except the 20% pension cut, which was directed by the authorities. Well, I have to make the communication thereafter. After few months, I got 1 or 2 months after I got. Well, not prior to that date of 17th of January. It's not that, my lord.
As soon as the court passed.
Government.
But they are creature of the statute. They are a constitutional body. We should have to pay respect to the constitutional authority.
That is not the issue here. The issue is whether you have to show any respect to the adjudicatory forum which order is binding on you.
Only to pay respect to the
That is the only thing. That is not
pay respect to
the issue that you are trying to introduce here does not arise here.
Pay respect to the judicial authority.
That issue does not arise here. The issue is whether as a secretary you can just sit over the order or you are required to take steps.
No, secretary passed after the approval from the governor. Secretary is no power until the approval.
Therefore, we are saying, what is the big rush? Why only 2 years?
No, my lord.
Why only 2 years? Why not 7, 8, 9, 10 years?
No, sir.
What was the big rush?
Kindly consider. We can write a letter and write a reminder, second reminder, then approach the court. Kindly do this is the difficulty.
Never approach the court. After rejection of your MA, you never approach the court. You could have approached the court. You didn't approach the court. So what about this functus officio? How that order is sustained? How is functus officio?
It may not be functus officio, but what the learned tribunal said, as because the time specified with a rider that if not within this period is the proceeding is concluded, the proceeding is vitiated. Now, I may not say functus officio is the right word used, but I may not be saying I'm before the tribunal. But the fact remains, after the 6 months period is over, the tribunal's opinion, it cannot do anything further. Had that been an application, I had the opportunity in one matter, my lord, where an application was filed within 6 months' time. But that was allowed. Another further 6 months were given by the tribunal. My lord, your lordship has seen the judgment of the Honorable Supreme Court.
Something else?
Yes.
Yes.
But only governor has power to approve. Under 10-1.
This must be the 10th time you are saying this. We are asking you something else. You are saying the same.
No, 7 except.
Times. Yes.
No, my lord, the judgment, my lord, of 2025, my lord, what I'm not banking on paragraph 62, it also says that even if, my lord, the extension was not granted and there is something, the authority should wait for an order of the superior court. then to pass the final order. Now, what they have done, my lord, they filed and
Where is
repeat.
that?
My lord, page 62, paragraph 62 of the judgment, my lord, your lordship kindly turns.
Yes, 62, that is what we are asking.
Yes, my lord, the middle portion, if your lordship takes up. Or in exceptional cases starts from exceptional cases, even after expiry of the stipulated time, such application can be moved, and depending on the cause shown or inability to failure to conclude proceeding within the time stipulated, as also for not applying for extension before the expiry. The tribunal court may, in its discretion, allow or reject the prayer of extension. If the application is rejected, the proceeding cannot be carried forward unless a superior court, reversing the order of rejection, permits the disciplinary authority to proceed. Secondly, if the delinquent employee objects to the continuation of proceeding beyond the time stipulated, the disciplinary authority, without proceeding further, ought to have applied for extension of time and may not go ahead till time its period of extension is granted by such application. Proceeding despite objection and without there being any extension could give rise to apprehension of bias. Well, therefore, applying the extension upon halting the proceeding, awaiting order on the application would be the advisable course of action to balance the interests of both employer and employee. Well, this makes things clear, my lord, unless this honorable court had occasion to, my lord, pass an order, either reversing or staying.
Challenge the 16 on 24 hours.
My lord, and my humble submission, my lord, that order is of no consequence. That's because, my lord, the order was passed when the matter was seen of this honorable court without any, my lord, leave. The order was passed. My lord, the issue before your lordship, my lord, whether the extension which was not granted can have any impact in this writ petition. So my humble submission, my lord, that order which was passed in 16/1/2024 is of no consequence to me, at least, or at least is non-est according to me in the eye of law. As because there is no leave granted, the tribunal order, good bad, well, I'm not saying good bad, the tribunal order remains, which, my lord, debars the authority to pass any order. My lord, have there been any order of this honorable court by which, my lord, the tribunal's orders have been relaxed, or, my lord, stay has been granted? I could understand, my lord, then 16(1) order I had to challenge. As because as of now, my lord, when your lordship is hearing out this matter, till date the tribunal order is good bad immaterial is still, my lord, is there on record. And that order says, my lord, you cannot proceed after 6 months, and the MA was filed, MA was dismissed. Now, my lord, not only that, my lord, learned senior friend has just pointed out the COVID application, COVID thing. My lord, the coordinate bench exactly dealing with this in a similar matter said, with regard to disciplinary proceeding, which is covered under the CCA rules, my lord, there is no time by which a proceeding is to be concluded. This limitation of, my lord, the period of limitation has been given by the Supreme Court. I've got the Supreme Court judgment, my lord. That is only applicable, my lord, when there is a limitation prescribed in the statute.
No. This 5-judge bench of your High Court is different.
My lord,
It is in addition to that.
Well,
This
this-
5-judge bench is in addition to
my
that.
lord, I mean,
It says conditional orders. The very it opens that paragraph opening is with conditional orders.
Yes.
my lord, my lord,
All conditional orders.
that order,
You see page 2 of the order.
my lord, order has been not been given to me.
Arre,
My lord, this
We understand you are talking about WPC 3.
no, my lord, this is the Supreme WPC 3, my lord. WPC 3.
I have understood what you are saying. WPC 3,
Yes,
suo
ma'am.
motu writ petition by
Absolutely.
the apex court. This is in addition. This is your High Court. See what it says in the second paragraph. It says whatever Supreme Court has ordered, that applies in addition. Conditional order. So this was a conditional order,
So this is conditional orders of the court, including that's
so this time, even if we give this time, even if we accept this, then this time lapsed in March 22.
this one, March 22.
So that they have taken all the time.
No, conditional আছে স্যার পরিপাতা আছে স্যার যশে মার্ক করে রেখেছে
Report submissions. Yes.
Yes. My lord, last occasion, my lord, your lordship was pleased to give direction for opposition. My lord, fixed on 12. My lord, till date, my lord, no opposition has been filed.
It's not here. You didn't ask him.
Mukherjee was.
Yes, Mr. Mukherjee, you are supposed to file opposition in this. The time for filing opposition is extended by
One week, my lord. Kindly, my lord,
Yes.
kindly date may be fixed, my lord.
for reply. We allow 1 week thereafter. List after 3 weeks on give a date.
Yes, sir. Well,
Item number 11.
None appears for the
Item number 12.
12, Lordship, I am for the petition, Lordship. Last occasion it was appeared, and Lordship, please to date us to last chance to file the reply. Reply is ready. I am serving the advance copy, Lordship. I am taking only 1 day time to take the matter, Lordship. In the meantime, I shall affirm that copy, and Lordship may please to take the matter on tomorrow or day after tomorrow.
do it, not today. List it on Monday. This is WPST. Oh, not today. It will come on Thursday. You complete the exercise.
Grateful, grateful. Then I have to serve the copy after affirmation that copy to sir.
You complete the exercise. That is what we are asking. Yes.
Grateful.
Item number 13.
Yes. You have informed the learned government pleader.
My lord,
Oh, you are appearing.
my lord, opposition has been filed by the. I have informed my lord. This is the affidavit of service, my lord. He kept on record, my lord.
But before his appearance, opposition has already been filed.
When Mr. Bashmalik was appeared, his
Opposition was filed.
the opposition reply all has been exchanged, my lord, and filed.
Yes. Let us see, yes, what is the
Can you come to their opposition, my lord? May I go to the gist of the case, my lord? Petitioner participated in the selection process of waterways and irrigation department, my lord, from circle number Western Circle 19, my lord. And my lord, after participation of the state selection process, my lord, the selection list was prepared, my lord, and that has been published, my lord, and all the petitioners have been selected, my lord. Thereafter, my lord, due to unknown reason, my lord, they rejected the said combined list from Western Circle. Kindly come to page 118, my lord, inner page, and present page, continue page, my lord, 137, my lord. As per the recommendations of the Chairman Central Selection Committee for South Bengal Selection Test conducted by the Subcommittee 3 has been constituted by Irrigation Waterways Department such and such stand rejected in order to conduct reselection test among the candidates number such and such appearing before the subcommittee number 3 following 3 subcommittee are formed. Therefore, committee has already been formed for reselection.
No, we are
Process, my
on the last date. You are appearing.
Yes, my lord.
We asked you what has been done.
But initially, selection process was challenged. Then the entire selection process was set aside by the tribunal. Then mana approach to the tribunal. Matter went up to the Supreme Court.
Yes.
Then mana order of the High Court was set aside. That
See, constitution of subcommittee number 3 was improper.
improper.
That result was set aside,
No,
not acted upon by you, not accepted by you.
but so far constitution of chairman, he misuses his power. We have initiated departmental proceeding against him, and he has been punished.
Whatever it is, but now the point is you have said that you will re-look into the exercise done by the subcommittee number 3. What have you done after that?
After that, 2006 election process started, and 2010 there is a notification was issued. Then after no further selection of it.
No.
No, in terms of the order of the Supreme Court, can't you see the order of the Supreme Court?
See, you have not challenged the tribunal's order.
No.
Have you challenged the tribunal's order which we are considering right now? Look at the order first, then make your submission. Don't go into history. Mr. Ghosh, learned advocate appearing on behalf of the state, what he has said. Read page 2 of the order.
My lord. Tribunal order, last page. Last page. A petition at last page.
You are saying because it is being looked into by the vigilance, we have not restarted. So we asked you how much time it will take.
Page কত? Page 126 of the.
Mr. Bose, learned advocate of the state, that is settled and dismissal the offended there is a report hence the question of government in
Now come to page 144. Everybody is saying it will be done. When it will be done? Read page 144. When they attain the age of superannuation, retirement.
144 সব দেওয়া আছে ওই অর্ডারটা রাখতে প্লিজ
A letter of 8 September 2021. Intimation will be given as and when the reselection process is conducted. When it will be done? 21 you are saying it will be done. Tribunal you are saying that it will be done. After all, when? How long? Therefore, we ask you to obtain instruction. How much time it will take? You have to take the action, the supreme, in terms of your own decision.
And very surprising thing is that, my lord, the Vigilance Commission, my lord, has been engaged, my lord, in respect of my lord, Damodar Circle, my lord, not Western Circle, my
So
lord.
let them say
And
that.
they filed their opposition with the opinion that, my lord, they, due to procedural defect, this panel, selection of Western Circle, my lord, has been a selection list of Western Circle has been rejected, my lord. My respectful submission before your lords is only what is the procedural defect? Who has made?
Now that can't be looked into.
This
That is over.
This is made
That
by
is
the
over.
concerned.
That is over. That you cannot agitate.
My lord.
That is over. Now there is no scope to look into that. That has been affirmed. Supreme Court has looked into it. The subcommittee 3 was found to be constituted not in accordance with law. Because only one portion of the candidates were suffering, there was a question of re-looking at it.
My
Now, therefore, they have to re-look. Now we can't reopen how the
Page 9 of the affidavit in opposition. Between opposition, paragraph 19. The subcommittee for registration has not been formed till now.
Sir, therefore, we are asking how much time? That's all we are asking. You have to take some decision. Yes. Let Mr. Mukherjee obtain space.
Order dated. One thing.
and it's a
2000,
page 65, my lord.
68.
Uh, August 13.
Page.
Page 68.
Page 68.
What is the date?
Date 13th August 2013.
So it has to be reformed, correct? Because this formation is of 2010. This is prior to the Supreme Court. Yes, you take instructions. List after.
Item number 14.
Very good.
923.
Yeah.
923. Move to the direction for filing opposition and reply. Opposition was filed. You have filed an opposition? Yes. In 25 minutes. The reply has not been filed. Last day also I asked for report, press report of after 23 they did not appear. Not up, no, after 23 they have appeared, but they have last 2 days, last date and today they have not appeared. And no reply has also been. It is of 23. Why to keep it? Why to keep it? Yes. Today is the
Item number 15.
May I am appear behalf of the petitioner. Mr. Apurva Kumar Ghosh is absent today due to demise of the father-in-law. I am praying for not this week, my lord.
on account of
Item number 16.
I'm for the petition. That's it, I have served all the respondents. I am appearing for this case.
they are private respondents also. They have been served. No, have they been served? Is service?
No, the track report is not. Yeah, no, sir, no, sir. Track report showing not served.
Please look into the affidavit before you give it to us. That is least expected from you.
This is delivered to the city.
So respondents, all respondents have been served. Let us see. How many private respondents?
One.
Is respond number?
With Xerox code. But before going to the YouTube order of the Lord Tribunal, what is my submission? I am a victim of the fact which for this I am not at fault. The petition of marriage with the employee since this took place in 8 May 2002. Now subsequently our marriage has been duly registered. In our married wedlock, his son was born.
Item delivered to sender as report as it appears. I give it.
Please be kind to us also sometimes. We find it very uneasy if we have to look into these things. We would rather rely on what you say than to look into these things.
I'm sorry.
We should not be required to look into it. Whatever you say, we should be able to accept it without on these issues.
Correct, it's our fault.
Yes.
Actually, we have not received any envelope, so under the impression it has been delivered.
Lawyers, 3 on your side. We discovered it in 3-4 seconds. 3 lawyers are standing there.
Also, I will sign.
Let us complete that exercise before we can go proceed. We'll see if required. We'll direct you to serve notice. What is the issue?
But the issue is that the second wife of the employee which is now Lordship, at the time of retirement, 2002 marriage solemnized, it was registered in our marriage wedlock with the deceased employee. His son was born. Now, Lordship, after the retirement, Lordship, up to till date, Lordship, the deceased employee and the present petitioner used to stay as a wife and husband. Now, subsequently, the husband expired. Now, I submitted a trade for pension at the relevant point of time.
He died in 22. Oh, marriage in 22.
Died in 20. No, died in 17. 8 January 22. Now, when I submitted application for pension,
And when the marriage was solemnized?
8 May 2002.
Yes.
It
Then
was registered in the married wedlock as per the.
when you applied for pension, what happened?
Now, as per the respondents, Lordship, in the service book, the name of another lady has been recorded as a wife. Now, subsequently, I gathered the husband, without giving any intimation to that effect, Lordship married me. Now I am before this court that I am a second wife, so I am not entitled to get the pension. Now, learned tribunal has committed a gross error. So, what is the gross error? That my son is entitled to get the pension, even he is an illegitimate child. That fair has not been also considered.
No, where is the rejection of his claim?
Page 23, my lord. My lord, kindly consider page 22, the representation, because that is very relevant, my lord. What was her prayer? We sought for family.
If you want to approach them for your son, we can allow you. They will pass an order. Admitted position recorded in the tribunal's order is that marriage was not dissolved. So therefore, we understand what you are saying, but that relief you have not prayed. If you want, without reference, without being prejudiced by any finding, they will consider his claim. We can fix a time frame rather than contesting the matter.
The judgment of this court, because
On what point? What
day,
point? What are you trying to? What is the submission in support of which this judgment you are showing?
this judgment also says same thing, that the illegitimate child with the second wife.
Issue not raised. When the issue is not raised, not decided, what are we to decide? We cannot substitute ourselves for the authority. You will approach them, they will ask for birth certificate, all those things you will show. If he is a son, then they will have to pass an order.
Already, Lordship, kindly come to my birth certificate of my.
This is not the forum to look into it. We are not going to do that. We asked you, where is your claim before the authority? This is not your claim. Page 22 is only for yourself, not for your son. And that has been rejected. Your son's claim has not been rejected.
Lordship, kindly come to the prayer.
Your son is born in which year?
2003.
2003. So, he is very much a major.
No, at the time of death, when the petition
We
was
are not on that. We are on, he is now an independent party. He is not under the care and guardianship of his mother. He is neither made a party in the OA nor in the writ petition. There is no prayer for any pension on his behalf. Then what we will do?
So what was my prayer?
Read the prayer.
Account page 34.
Yes, we are looking at it.
An order was set aside in the issue dated 14 March 22.
Correct.
By the Deputy Secretary to the Government of West Bengal.
Correct.
Water Irrigation Development Department.
Yes.
An order directing the respondent to reconsider the case of the applicant.
Yes.
An order directing. So, Lordship,
Therefore, no prayer for the son anywhere.
at the time of death of my husband, my son was 9. I have prayed.
We are not going to look into something which was not the subject matter before the tribunal. We will not look into.
It was the fact before the tribunal that in our married wedlock a son was born.
Maybe he doesn't want anything, he will not get anything.
But also the tribunal ought to have been considered that.
No, not unless you pray for. Not required.
Kindly come again, read the prayer.
Please again read. You may read twice.
Okay. First prayer is set aside in the impugned order.
Yes.
Second is direction to reconsider the
Applicant. Correct. Therefore, we have at the outset said he is not a party either before the tribunal or before the.
Ought to have been considered.
Everything they ought to have done, you do nothing. You come only to the High Court under 226.
No, I have prayer before the.
Where is that prayer? We are asking you. You are running in circles.
Also, kindly come paragraph 11 of the tribunal application case 35.
Yes.
Following interim orders. In view of the fact the applicant with her unemployed sons are passing.
An interim order can only be in aid of the final order. The final relief is only for the applicant. The son is not a party. By no stretch of imagination, the tribunal could have passed any order for the son. Who knows? Maybe he is employed. We don't know. He is born in 2003. That's why we asked you. Today he would be 23 years old. We don't know where he is, what he is doing, whether he is running a business, he is employed. We don't know.
This was the duty of the respondent.
Yes, everything.
When the petitioner is.
Now, where is that duty? Show the duty. That when no relief is claimed for, prayed for.
This was the judgment of the Honorable Coordinate Bench. Kindly consider this judgment.
Yes. You are inviting us to say something, then we will say it. If you are inviting us to say something, then we will have to say something.
So I am just only praying for faith.
No. Therefore, we are saying there are two options. One is you have not prayed for anything on behalf of the son. He is not before us. We will not make any comment on his entitlement. We don't know whether he wants it, whether he doesn't want it. He is a major. He is not a minor. Therefore, where is the question of saying anything?
I'm just praying paragraph 5, not giving trouble to read entire order. Kindly come page 5, last paragraph. On such consideration, I do not find.
Now come to the second paragraph at page 1.
Yes, same.
That's not your prayer before the tribunal to pay to all the legal heirs. Only applicant.
Kindly come paragraph 5, last.
Paragraph 5 will apply in the facts of the case where the prayer was for all legal heirs. In your case, there is no prayer for all legal heirs. Only for the applicant. That's precisely what we said at the outset. You are unnecessarily trying to harp on something which cannot be done. You know well. And will not make any observation. We know why you are making so much submissions. We will not make any observation. He is not before us. We don't know what he wants and why he was not made a party. He is not a minor that we can make any observation in his favor. He is 23 years old today. Where he is, what he is doing, we know nothing. And you cannot take liberty to make a prayer for him also. What can be done? You will have to go by the facts. You can't improve the case. That's all. Yes, take down. You said consider, so we considered. Now, call the next.
17,
It appears on the petitioner. But there is a direction to file, serve the learned advocate.
So it is served.
It has been served upon the learned. Initially served upon the party concerned. Since nobody appeared, you are also directed to serve upon the learned advocate.
Oh, this is to the advocate.
Advocate.
Why by post? Why the advocate should be served by post?
Because in a tribunal.
He is not a practicing lawyer here.
Not.
Who was appearing?
R.K. Mondal.
There is a final order passed by the tribunal.
Yes.
Then what, how the tribunal's lawyer will be having any connection with the case?
No, because we have served upon the party concerned. There is a direction.
Direction to
Served upon the learned advocate.
Earlier you have served on the
Party. The death took place on 31st October 2013.
That's why the direction was given up.
It was not served. To him.
Already recorded. Please.
Not delivered.
That is the last.
Out for delivery.
Insufficient address.
We will pay service.
Let notice be served afresh.
Okay, item number 18. Mr. Pankaj Haldar had been appearing for the petitioner. Lordship, I am seeking 2 more weeks of time. Because Lordship, if Lordship kindly peruses the previous order, Lordship, there was a direction to file, Lordship, a clear legible copy of the original application along with an exhaust and also the translated copy thereof.
Copy of the Bengali documents are there.
So, Lordship, my instructions for Mr. Halda is the application has already been made before the tribunal for the certified copy of the OA, Lordship. As soon as we get it, we'll get the annexes translated and Lordship will file. I'm only, my Lord, praying for 2 more.
Further time.
Four weeks.
4 weeks.
Item number 19.
After 4 weeks, keep it on 16th. Why? 16th is the date fixed for WPST. Oh, this is old matter. How it is old matter? These are 23, 24 matter. Oh. Oh, in old matter.
Application was rejected on the ground of limitation. Order was passed on 2nd July 2019. Application filed on 15th April 2014 without miscellaneous petition for condonation of duty. And page 35.
His compassionate appointment was rejected.
Yeah, for compulsion. 2nd July 2019, order was passed.
None appears.
Item number 20.
Item number the petition. The affidavit service. Well, may I file the affidavit, sir? I do the sir. Page 234, my lord, the impugned order, my lord. Oh. Oh. I should do what to do.
Where are the two orders?
My lord,
WPST 329 and WPST 330.
my lord, order, my lord, the learned single judge, my lord, at page 192.
WPST 329.
No, no. Writ petition. Oh, 184. Hello, 184, my lord. Hey, ordering question at 187. That is, my lord, the division bench, my lord, on earlier round of litigation. 187.
For the applicant there, writ petitioner.
My lord, some of the applicants, petitioners are there.
After this